Afternoon. Ish.
How are you this afternoon?
I'm good. I'm fine. How are you?
Confusing, eh? It's confusing. Eh? I also thought first thing that came into my mind was morning.
Yeah, it's
Yeah,
crazy. Well, 12 o'clock is always tricky. Mm, I can't even call it mid-morning. It's like early afternoon.
yeah,
And
early after.
honestly, and it's a Sunday. So, yeah,
Hey,
feels
the
like morning.
weekend flies. Eh? The weekend flies too, eh?
Yeah, it
Okay.
really did, especially when there's something you need to do.
A very good afternoon, Tim. How are you?
And thank you. How are you?
I'm very well. Welcome to Radio 54. I think we are on time, or am I late?
You're right on time.
Okay, thank you so much for being here. We are live now. I don't know. Can somebody mute me? There's someone on radio.
Not
Okay.
me.
Not me.
Oh, okay. So I don't know what's speaking the sound. I can hear myself in another, like in the background. But yeah, it's okay. It's sorted now. To those who just tuned in, this is Mata Matarinda Shumba on Radio 54 African Panorama, bringing you live. We have PACTA, which is a Pan-African ICT Association, which is an association for ICT companies and organizations in Africa, and together with Beetroot Africa, which is led by Miss Minili Tagure. And we're bringing you a topic that's going to be led by Hugo Biermann. I was asking Mini to send me a voice note. Like, how do I pronounce that? I need to know. Sorry, I'm so sorry. It's like asking someone. It's like asking someone to say Tambudzai.
No, that was excellent, Martha. Perfect.
All right. Thank you so much. Welcome to Radio 54. And the topic today is IP protection and technology commercialization. And okay, I can hear the background. And the focus is on what is intellectual property, protecting your intellectual property, role of IP in technology commercialization. I know that it's a topic that most people are not really familiar with, and not knowing that we deal with this almost on a daily basis. Be it business, entrepreneurs, organizations, even the politicians, like I mentioned earlier. Okay, they deal with this, but not much information is being shared out there. And I understand that Hugo, you are a senior associate at ENS Africa's Intellectual Property Department. And yeah, as much as we really know that these things exist, there should be IP protection and so forth. Why is it there hasn't been much communication, be it on mainstream media, be it through the government, to get the word out there on what people need to do? Is it lack of platforms, or what's the story?
Yeah, I think it's a good point that you make, Martha. I think it's a tricky one. I think it's one of those things that might be seen as a little bit of a dark art. You know, it's one of these very specialist fields that are so complicated to deal with that you need to be a specialist to understand it and to deal with it. And I think the government and private organizations like PICTA and Beetroot are, making strides towards making it more accessible to people on the ground, because it's such an important topic. And I think, as you rightly pointed out a few minutes ago, it's something that you deal with every day, even if, whether you know it or not, you're being exposed to it every day. And I think that's the purpose of today's chat, is to just share some information, make it more accessible to people, because while it is a specialist field, I think it's still not too difficult to just understand the basics so that you can make sure that you protect yourself, protect your business, especially for small businesses. It's so important just to understand those basic elements when you're commercializing your technology so that you can be protected. And that's why I'm really excited about today's chat.
Okay, all right, okay. Thank you so much. Before I had to shoot that question, just before we can we can go anywhere else, because somebody was asking questions like, when we talk about IP protection, it's something like non-existent. When we look at at companies and organizations here in Africa, they are just running without even protecting their ideas. So can you take us a brief about what ENS Africa is all about, what they have done, and so forth, the general information of what the organization is about?
Yeah, ENS Africa, we are the largest law firm in Africa, actually. We've got offices across the continent, and we deal not only with IP, intellectual property law, we deal with all aspects, or most aspects of commercial law. But for the purposes of today's discussion, I think intellectual property is an important topic, and it's something that we deal with across the continent. So we assist clients and inventors in identifying intellectual property, identifying their rights, advising them on how to protect it, and then if it's necessary to enforce, then we also can assist with enforcement against third parties who might possibly be infringing those rights. And to get to your point on sort of a lack of IP awareness across Africa, I think things are moving in the right direction. I think to an increasing extent we're seeing that people, and especially in the ICT space, people are becoming more aware that intellectual property is in many cases the most valuable asset that a company has. If you think about big companies across the world and in Africa as well, often their intellectual property rights like trademarks, patents, copyright, those things can be the most important assets that they own. And I think maybe Africa was lagging behind a little bit in terms of protection and enforcement. But from my perspective, what I've seen over the past few years is that it's definitely moving in the right direction. And I'm actually quite excited for that, because it's one of those things that it is actually like a physical asset, like land or a house or a car. IP should be thought about in the same way, that it's also an asset that you should be protecting and exploiting. And once you become comfortable with that, there's really a lot more value that can be unlocked.
Okay. Wow. Thank you so much. I believe that I'll also share your website and so forth, so that people wants to get in touch will know where exactly to contact you. Also, at the end of the show, you can share the details and so forth. I would like to thank PACTA, led by Mr. Sonwabo Mdwaba, and Beetroot, led by Mini, to they managed to put together this and say this is a topic close to our hearts, and we believe that it should be out there. And on that note, I really want to appreciate you guys for always coming through where technology is concerned, and wanting to always share as much as you can. And will be to you. This is for you, Hugo, and Paita and Beetroot. You are more than welcome at Radio 54 to share anything and everything that has to do with technology, IP protection, technology commercialization, entrepreneurship. Because we can discuss any other topic, we can go all out and talk about everything else, but things that are really happening out there, that affects our business life, that affects our companies. We put them aside, but there are real issues that needs to be tackled. So thank you very much. Mr. Mdwaba, I would like, before we go to Hugo's presentation, I would like you to once again introduce what PACTA. PACTA is, I can say, it's our partner at Radio 54 African Panorama, because they always bring topics here, bring presentations, webinars, and so forth. So I would like you to introduce one more time what PACTA is all about, and for our listeners.
Thank you very much, Martha. Good afternoon, all listeners. I think it's important for us to introduce PACTA. PACTA is inspired by the former president of South Africa, Mr. Thabo Mbeki's vision for our continent, as well as the ideas of pioneers of Pan-Africanism, such as President Kwame Nkrumah of Ghana, NASA of Egypt, and from the African diaspora, Mr. Edward Blyden and Mr. W.E.B. Du Bois and Mr. Stokely Carmichael, who developed Pan-Africanism into a machine to advocate for Africa unity by tackling common issues affecting the continent. Although PACTA is a new organization like the movements before it, it aspires to the main goal of the Pan-African movement, which was to get Africans all over the world to unite and to work together for economic independence in Africa. The relevance of the unity of purpose in 21st century is very pronounced, especially in the digital or technological age and COVID-19 times. To this end, PACTA advocates for an integrated digital continent, united based on ideas of Pan-Africanism and the vision of Africa's Renaissance. Our organization's quest for African unity has been inspired by the spirit of Africanism, focusing on women, youth, persons with disability, inclusion in the digital era, and economic emancipation. It is motivated by development based on the self-reliance and self-determination of the African child being part of this digital transformation. PACTA is a digital transformative body formed in July 2020 in the interest of communities, ICT hubs, SMME development, sustainability, women, youth, persons with disabilities. PACTA is seeking to forge a partnership or partnerships with other organizations and institutions alike. PACTA has to deliver its strategic objectives for Africa's rural, peri-rural communities. I'm sure we all know the struggles of the rural and peri-rural communities in the rest of the continent. So how do we reach objectives? By creation of an enabling developmental ecosystem, bridging the digital divide across Africa and accelerate Africa digital transformation access through the creation of an innovation factory hub for access of the excluded, training, skilling, reskilling, upskilling individuals from communities. Connectivity being a very sticky issue in the rest of the continent. This was prevalent in the rest of the world when COVID-19 struck last year. It was clearly indicated or shown that there is a problem with connectivity. So PACTA, through its competency and capacity, will provide guidance on internet access, digital infrastructure and devices, promoting digital culture and communities. We want our communities to take ICT or IT as waking up in the morning and washing your teeth. You know, it's as easy as that. People must know what it is. It must not be a foreign concept. Developing platforms that provide information and market access opportunities. And we are saying that when you're looking at PACTA, we've grown since the last time we were live on the show, Martha, and always appreciate you hosting PACTA and being partners. PACTA, if we are to use a PACTA and use a synonym of a tree, the association has grown branches to focus on critically important areas and has created Women in Digital Era, which is called WIDE, Youth in Digital Era, Institute of Technology and Science, Fourth Industrial Revolution Chapter. We have partnered with various organizations, institutions, and even few countries. For this particular event, it is clear, I'm sure, and you've introduced it. Beetroot is our partner, and we are proud to be sitting here with Beetroot and ENS Africa and yourselves as Radio 54. Thank you.
All right. Thank you so much, Mr. Mdwawa, for the introduction. Thank you so much. We really appreciate you. We really appreciate the work that you are doing in the ICT space. And I think everybody by now knows that I head the entrepreneurship department of PITA. And so I'm not just a pretty face on radio. So I had to rub that in. This is for for my friends and relatives out there. Miss Mini and Lamini, wow, this is me giving you a husband. But anyway. Dagwire, thank you so much, for everything that you have done. I've been engaging with you like the whole week, calls and everything, trying to make sure that we are on top of our game. And I want to thank Beetroot for this. And I saw what you also engaged in entrepreneurship on the last webinar that you hosted. Can you take us through what Beetroot you have done so far regarding technology commercialization? Oh, she's
You had every hello?
Yellow, yes.
Yes, all right. I was saying I'm not sure I can follow up on Sonwabo because geez, I didn't write anything down. So
No, it's okay. It's just for the intro. It's Hugo's day, by the way. So you too, I'm watching.
Yes. Okay, so basically, Beetroot is started as an online magazine for entrepreneurs that were starting out and that could not get enough media coverage. So I just created this magazine to feature these entrepreneurs that are starting from the beginning, that are not there yet to be praised by Forbes or Time magazine. So yeah, they come to Beetroot, and we help them with a lot of services, from market linkages to getting them investor ready for funding, and also featuring them in the magazine interviews. We host events like this. We have our SMME year-end gala, uh, and we actually do a lot of stuff with them, from their marketing plans, business plans. This has nothing to do with the magazine. The magazine is just to show what they're doing, and we talk about them. So our main aim with Beetroot is to promote sustainable development in Africa, and we are doing this through supporting and promoting entrepreneurship. Sorry, my breath is kind of I've had a bad flu this week, so yeah.
Flu?
Yeah. I'm still trying to recover, so I have to catch my breath while I'm talking right now. But
It's
yes,
okay.
yes, it's more about promoting entrepreneurs, supporting entrepreneurs, trying to open new markets for them, trying to educate them, exploring new opportunities for them, educating them like we are doing right now. So yes, that's what Beetroot is all about.
All right. Thank you so much to those who just tuned in. This is Mother Matarenda Shumba on Radio 54 African Panorama, your Pan-African radio station represented in 55 countries and also out of Africa. Today we are joined in by PITA, Beetroot, and ENS Africa. With Hugo Biermann, who is a senior associate at ANS Africa's Intellectual Property Department. He specializes in patents, registered designs, and the commercialization of IP. Hugo has a degree in law and engineering and is a registered South African patent attorney and certified patent valuation analyst. He also acts for clients in a variety of industries, including IT, fintech, telecommunications, robotics, security, mining, and manufacturing industry. He also works with a number of universities, research institutions, and development agencies. And Hugo's experience also includes assisting clients with patents and designs applications locally and internationally, as well as providing novelty, infringement, and validity opinions in respect of patents and design. So we are not talking about a small person here. This is somebody who's been doing this for quite some time, and we are going to learn a lot from him. So stay tuned. www.radio54africanpanorama.com on our Facebook. That's Radio 54 African Panorama Live. That's also YouTube, Radio 54 African Panorama as well. We are also live on Picta YouTube. So to those who just tuned in, you can pose any questions. We are here with you. And I'm just going to put this over to Hugo to give his presentation. Should I add the presentation to the stream, Hugo?
Yes, please, Martha, if possible.
All right, that's fine. All right, there we go.
All right, great. Yeah, I think we can see it.
Yes.
Yeah,
yes,
thanks.
we can see it.
Perfect. Thanks, Martha. Thanks so much for that introduction. And thanks so much, Radio 54, and also to Paita and Biju. Thank you so much for this opportunity. It's really an honor and a privilege to be able to partner with you and to bring this message across to the listeners and the viewers. I have a presentation here. I'm aware that not everyone has sort of visual access to this, but those who do have visual access, you can have reference to the presentation. But for those who are only listening in, don't worry. I'll talk through everything as well. So today I want to share with you a little bit about three topics, and that is firstly, what is intellectual property, or IP as we call it? Secondly, how do I protect IP? How do I protect my intellectual property? And thirdly, how do I use intellectual property in commercialization of my technology? Now, obviously this applies to sort of all sorts of businesses, big and small. I'm going to focus today more on the perspective of the small business, the entrepreneur, and especially those in the ICT space and the software space. That's also an industry that I deal with quite a lot and I'm quite passionate about. So firstly, what is intellectual property? Intellectual property, or IP, as we call it for short, is, as I said in the beginning of today's talk, it is property. Just like a vehicle or a piece of land, it should be seen as a piece of property, but in this case, it's not necessarily a tangible property. So it's different types of rights that are associated with creations of the mind. So when you come up with the creation, invention, that type of thing, that is where intellectual property comes to play. And I'll explain all the main types of intellectual property quickly, just because I think it's very important to just understand and unpack different types of intellectual property. And then from there, we can discuss how you can protect each of those. So just to give a very quick overview of the different types of IP, and most of the listeners and viewers probably know or have heard the words before, and I trust that it will make sense. So I think a patent is probably the one that everyone knows about or has heard about. It's sort of a buzzword, and a patent is really something that protects a new invention or new technology, and we'll get into that in more detail throughout the talk. Then a design, or a registered design as we call it in South Africa. Maybe let me just pause there. Most of the words and terms and rules I'll be talking about today, I'll be talking about from a mainly South African perspective, because I'm a South African attorney. The intellectual property rules and laws are fairly universal. So most of what I say will apply in most countries in Africa. But just bear in mind that I'm focusing mainly on South Africa, and the rules can be a little bit different from country to country. You know, for example, Kenyan or Zambian patent laws might differ a little bit from what I say about South Africa, but the general principles are fairly universal. So designs, or registered designs as we call them in South Africa, those are things that protect the appearance of a product. So whereas a patent protects an invention or a new technology, a design is something that you register to protect a novel appearance. A trademark, I think, is something that everyone also knows about or has heard about before. trademark is, in my view at least, in most cases, probably one of the most, if not the most valuable asset of a company. So the trademark is mainly your brand. So if you think about really, large organizations like Coca-Cola or Nike or Adidas, the first thing that comes to mind when you hear those words or when you think about them is the brand, the trademark, the logo. And that is really something that is extremely important to protect because, as it says on the presentation there, a trademark is a badge of origin. So when you hear the word, you think about where it comes from. It's this indicator of quality, and we'll get into that in more detail. Then the fourth type of intellectual property that's very important, a little bit tricky as well because it's a bit different to the others, is copyright. And copyright is something that protects what we call works. So those are things like books, songs, works of art, software, and it's a little bit tricky to deal with because it can't be registered in the normal way, but I'm going to get into that and explain that a little bit later. Then another interesting form of intellectual property that I'm not going to go into too much detail about is plant breeders' rights. But I think across the African continent, it's also a very important IP right that is often neglected and should be thought about is the fact that you can actually protect and get a registration for new varieties of plants. So obviously we can talk about that maybe after today's discussion if anyone has any questions about it. Then I think the sixth and final form of IP that I'll be talking about today is this almost more abstract form of IP that's known as know-how, or it's also known as trade secrets. So that is almost like a body of knowledge that you have as an entrepreneur or inside of your business. It's not necessarily registered as a patent or a trademark, but it is this business information that you have. It's usually confidential information that you have that gives you a competitive advantage. And that can be extremely, extremely valuable. And it should really be handled with care and it should be protected. And I'll get into that as well. So that's just a summary of the 6 sort of main forms of IP. And for those of you who can see the presentation, this is a slide that I usually use because I just find it's a nice way to explain all of the different forms of IP. So for those of you who can't see, what's on the screen at the moment is a picture of a Panado bottle. That's in South Africa, a very well-known painkiller tablet product. And it's actually a very nice way of thinking about how all of the different IP rights are at work and the interplay between them. And how they can all, or almost all of them, be present in a single product. When you think about Panado, this product that you buy and that most of us know about, the first thing that comes to mind is a trademark. The Panado, it's such a well-known trademark, such a valuable trademark, and the Panado is the badge of origin. It tells you where the product is from. It's indicative of quality. You associate a certain quality or standard with it, and that's the trademark, is Panado. In copyright, there's copyright present all over the place, on the words, on the outside, on the package insert, even on the little drawings on the container. All of that is protected or covered in some way by copyright. Then patents, that's where you get more to the technical side of things, like the formulation of the product or the manufacturing method. If there's a special way in which it's manufactured, those things can be protected by patents. Then a design, as I said earlier, is something that protects the appearance of an article. So you can have a design registration for a container if it has a new shape. I've even seen people registering designs for the actual shape of the tablet, if that has a unique or a novel shape. And then, of course, know-how and trade secrets. There's immense value. I think, if I remember correctly, Panado is sold by Adcock Ingram, large pharmaceutical company, and I am sure that there's so much business information and process information and customer lists, etc., that they have inside of their business that they keep confidential, but that gives them a competitive edge. And that is also a very valuable form of IP. And I think this example just explains that when you look at a product, it can be a simple product that it seems like it's been there forever, but there can be still be so much intellectual property involved in that product. So that brings me to the next section, and that is how do you protect these? And I'll talk about each form of IP individually, separately. So we know now, you've got patents, trademarks, copyright, designs, you've got all these things, but how do you protect them? How do you make sure that you don't lose your rights? So I think we can look at trademarks first. Probably the most, although I'm not a trademark attorney, it's probably the most interesting one, just because it's so topical always. So a trademark is actually, it's very broad. I said earlier that you think about things like logos and brand names, but it's so much more. Trademark is basically anything that can distinguish your goods or services that you offer from the goods or services of others, your competitors. So trademark can be something simple like a word or a logo, but it can even extend as far as something like a jingle or a smell. So anything that can be represented graphically and it can be used to distinguish what you do from your competitors can theoretically be registered as a trademark. And there are some interesting examples of that. So for example, we all know that the main examples of logos and words, but even things like colors. So for example, the color of Cadbury chocolate, that specific shade, I think it's a shade of purple that they use. I think in some countries they've been able to register that color as their trademark. And the sole of that red sole of a specific brand of ladies' shoes, I'm not going to try and say it, I might get it wrong, but I know that red color of the shoes has also been registered as a trademark. Those are just sort of some more far out interesting examples. Sorry, Martha.
No, it's okay. I'm saying wow. Yeah.
I thought you were helping me to remember the name of the shoe brand, but
No, not really.
It's the red bottoms. I call them bottoms.
yes.
Oh, the red bottoms. Wow.
Yes.
So that just shows you sort of the scope and how broad the protection can be. It's not necessarily only the name of the company or the name of the brand. So I think I'll just talk about this slide first. So, and this is very important, and especially if you're an entrepreneur starting a new business, startup company, it's very important to think about the brand or the trademark that you are going to use, because it's very important to pick a strong, what we call a strong trademark. And what that really means is that your trademark is distinctive and it is able to distinguish your goods or services from those of others. And there are some tips that I can give you, to make sure that you choose a trademark that is strong. And the first thing that's very important is the trademark should not be descriptive. And what we mean there is it shouldn't describe what you do. So for example, if I have a new startup company and I sell coffee, it's not a good idea to use the trademark hot coffee. My company's name is Hot Coffee. Or I start a plumbing business and I call myself Mr. Plumber. Now, it's not a great idea from a trademark protection perspective because it describes what you do. And because it describes what you do, you can't prevent other people from using it. If I name my business Hot Coffee, I can't stop my competitor from selling hot coffee. I can't say, well, now you're infringing my trademark, because it is a descriptive term and it's often required for use in the trade. So that's the first thing, is that it shouldn't be descriptive or required for use in the trade. And then you should also guard against your trademark becoming generic. And possibly the best example of that is the word Google. So what happened with the word Google is it's obviously a trademark, but over time, people started using it as a verb. So when I go onto the internet, even if I'm using an iPhone with a Safari browser, I will say, oh, let me quickly Google something. And when that happens, the trademark starts to lose its value because people are using your trademark for everything. Yeah, and there are some other examples like that as well. Things like the word escalator, the word Velcro. A lot of these words were actually the trademarks, the original trademarks of the original product. But the word became so generic that now, irrespective of the brand, people are using that word. So that's also something to guard against. Now, some more sort of concrete examples of what makes a strong brand. So I've said now that it shouldn't be too descriptive and it shouldn't be generic. So what should it be? So there are basically three categories of trademarks that are seen as being strong trademarks. The first and probably the best one is what we call coined trademarks. So that is, in layman's terms, that's made up words. So the best trademarks are usually made up words. So that would be something like Kulula or Google, Adidas, Nike. And the reason why they are great trademarks is the word doesn't have any other meaning. So your competitors can't reasonably say that they need to use that word. So that's why the best trademark is a made up word, because it gives you the exclusive right in that word. Your competitor can't come along and say, no, well, I need to use this brand. I need to market my product as a Adidas shoe, because there's no reasonable reason why you would need to do that, because I made up the word, you know. So that's generally seen as the best or the strongest type of trademark. Then another very good option for a good trademark is what we call arbitrary trademark. So that's where you use a known word, but the word, you're using it for a good or service that it's not related to. So for example, using the word Apple for a computer or a cell phone is a good trademark because the word Apple doesn't have anything to do with computers or trademarks. Other examples there on the screen, using the word Shell for a petrol station, using the word Camel for a cigarette, or BlackBerry for a cell phone. Or another example would be using the word mango for an airplane. That's a good example of a good trademark because your competitors can't really come and say, well, I need to use this word, or I need to use a similar word, because the term doesn't have anything to do with it. Then the third category is what we call suggestive trademarks. So that's where the name sort of tells you a little bit about what the product does, but not enough. It's almost suggestive. And that would be something like Coca-Cola or ShopRite or Bio Oil or Vodacom, where it has a little bit in there. It sort of tells you the industry, but it doesn't tell you exactly what they do. And that's also okay. So when I'm saying a strong trademark, I mean from a trademark protection and registration perspective, and from how easy it is to enforce from that perspective. I'm not saying you can't use a weak trademark, you know. I'm just saying it will perhaps be more value, and it will be easier to take action against the third party if you do use a strong trademark. Sometimes, even if you didn't pick perhaps the best trademark in the beginning, you maybe picked a very descriptive word. It's still possible to obtain strong trademark rights. If you gain a strong reputation in the product or service, you'll still be able to get trademark rights and maybe get a registration or take action against people who use confusingly similar marks. Another one that I forgot about, Minnie, is Beetroot, which is also a very good trademark for what you do. It's an example of a very good arbitrary trademark. So it falls into that second category. So what rights do you have if you're able to register your trademark? It does give you very, very strong rights in many cases, and basically it allows you to stop other people, other parties, competitors from using either the same trademark or a trademark that is confusingly similar. So it doesn't have to be identical, but it can be confusingly similar. So if someone registers, for example, a company name or a domain name or a Facebook page or something that it's either the same as your trademark or it's confusingly similar. So what that means is if a member of the public looks at it, they would think that it's the same or it's associated. And it allows you to stop other people from doing that. And the reason why it's good to actually register the trademark, so to actually go and file an application and get it registered, is because without the registration, it's much harder to take action against someone. So let's say I have a trademark that I use in my business, but I don't have a registration. It's not a registered trademark. I just use it. And someone else copies my trademark. Then I would actually, in South African law, I'd have to go to court. And the first thing I'd have to do is actually go and prove my reputation. So now I have to go and prove, how long have I been using this trademark, examples thereof, what rights do I have, and only then will the court allow me to take action against this infringer. Whereas if I have a trademark registration, the registration itself is proof. So you don't need an additional burden of now actually going to prove your registration. So that can be a massive advantage, both from a time perspective, but also from a cost perspective, because you really don't want to be going to the South African High Court and going there and trying to prove your reputation, for example. So I think that's what I wanted to say about trademarks. So I think what's the takeaways there are, it is something that should distinguish your goods or services from the goods or services of others. And that's the important part, is that distinguishing element that you need. Then I very quickly want to talk about copyright. I think it is important. And I said initially that it's a little bit different in the sense that trademarks, patents, and designs are things that you can register. So you can actually go and file an application and register it and get a registration certificate and get that proof of your rights. With copyright, for most forms of copyright at least, and in South Africa, it's something that comes into existence automatically. So as soon as that work is created, the copyright exists automatically. For example, if I write a book, or if I create computer code, or if I write a song, the copyright comes into existence automatically. So there's no requirement for me to go and actually register it. It does differ a bit from country to country. Certain countries like China and the USA, there are certain forms of copyright that you can register. And in South Africa, you can register the copyright in a film, but for nothing else. All of the others, there's no registration procedure. So I think there's a long list on the screen of types of works that can get copyright protection. But I think what's important from an ICT perspective is computer programs. So as soon as a computer program or a piece of software, code, module is created, copyright automatically comes into existence. And what's very important, and I'll touch on it a bit later as well, is to make sure of the ownership of that copyright, because it's not always simple to determine who actually owns that copyright. And that is something that is very important to think about, but just know that copyright does come into existence. So for copyright to come into existence, there are two main requirements. The first one is it has to be original. So obviously you can't just copy someone else's book or song or computer code and then expect to have copyright protection. In fact, you would probably be infringing their rights. So that's the originality requirement. And then extremely important is that there's no copyright in ideas. And that is also to a very large extent true for most IP rights. So for example, if I have an idea for a great new business, or if I have an idea for a new film or a song, but I didn't reduce anything to writing, it's just an idea in my head. There's no copyright in that idea in my head. And from the other forms of IP perspective, it's also very difficult to protect. So it is very, very difficult to protect something that's just an abstract idea in your head. But once it's been reduced to material form, so it's been written down, it's been published, that type of thing, then yes, the copyright does exist. And I'll get to the idea in your head a little bit later when I talk about patents as well. The third form that I just want to talk about very quickly before I get to patents is designs. And as I said in the beginning, a patent protects an invention, but a design protects the appearance of a product. And a design for me, and I work a lot with designs, is almost like a neglected the ugly stepchild of intellectual property rights. Not a lot of people know about it. Not a lot of people use it. They're typically more fixated on things like patents and trademarks. But a design can be an extremely useful form of protection. It can be a quite limited form of protection because it just protects the appearance of a product. It doesn't protect the concept or the process behind it, but it's not that difficult or expensive to get a design registered, especially when compared to a patent. And you can stop others from copying the appearance of your product. So it makes it an extremely valuable right, and it really is something to think about. In South Africa, we've got aesthetic designs like we show on the screen there. So those are designs that basically look nice. That's something that you see and it has this new visual appeal, something like a new cell phone. It has a new visual appeal, it looks great, and you can register that new design. Then you also get functional designs. So that's where it has to look a certain way to fulfill its function. So it's not necessarily that visually appealing, but it has to have a certain look to fulfill a function. And both of those can be registered as designs in South Africa as long as they are new. And that is a very important requirement for designs. Your design has to be new, and you need to make sure that you file a design application before your design is made available to the public. I'll get to that with patents as well. So it can be a really, really nice right to have this right of a design registration. But as I said, the design does not protect a concept or a process. If someone makes a product that doesn't look the same as yours, your design won't protect you. So that's now where we get to patents, where patent is almost like the crown jewel of protection for an invention or for a new technology, because it can be a broad form of protection, as it is not limited to specific appearance. So what is a patent? And fundamentally, a patent is, to use the Latin word, quid pro quo. That means something for something. So I have a new invention and I disclose my invention to the public, and in exchange for that, the government will give me a certain limited monopoly for a certain number of years to exploit that invention without competition. So that's why we say something for something. You get a patent, but in exchange for that, you have to disclose the invention. You have to disclose how it works, so that one day when you no longer have the patent, the public can be aware of your invention, and that leads to the advancement of technology, because the body of public information becomes broader and greater. And there's lots of philosophical debates that we're not going to get into today. I don't think we have time about the patent system and whether patents should be waived, especially with the whole coronavirus pandemic. People are talking a lot about patents. But fundamentally, patents are aimed at stimulating innovation. It's aimed at, you have paid a lot of money to do research and development, a lot of resources have gone into it, and you need some sort of protection, because you don't want to launch your invention and immediately everyone starts copying you. So essentially, you get no return on investment. So the patent system is intended to give people that return on investment, to encourage them to actually make the investment and not just wait for others and then copy them when they launch the product. But I'm not going to get into that in too much detail. I can really talk about that for hours. So a patent is not necessarily something tangible. It can be something like a method, a process. So especially in the ICT field, we see a lot of patents that are not necessarily something physical. It's almost like a method, a method of communication, or a method of encrypting information, a method of making a phone call. Anything that is new and inventive, even if it's not tangible, can theoretically be registered as a patent. This slide on the screen now, for those who can see, is a really nice way of understanding the difference between a patent and a design. So if you, just for the benefit of those listening, I've got a picture of a really nice car on the screen. And if you look at a car, there can be patents and designs in that car. The designs would be for the visual features. So the shape of the vehicle, let's say you've designed the steering wheel, and seats, things like that, can be registered as designs. But the patents are for more hardcore technological innovations. So things like fuel injection mechanisms, how it uses GPS, the battery, all of these more technical innovations can be protected by way of patent. So in many cases, what we see in practice is that people register patents and designs for a single product, but just for different aspects of it. And of course, trademarks for the brand that they use with the product. So when you have a new invention, let's say you've come up with a new invention in the ICT space, we deal a lot with things like apps these days, where people are looking for protection. What are the requirements for something to be patentable? And to be honest, the requirements for patentability are quite onerous. It's not easy to get a patent. The burden or the hurdle that you need to get over to get a valid patent is quite high. So the first thing is the invention has to be new or novel. So that means it has to be a world first. So you or your company has to be the first company or person in the world to have developed an invention like this. So you can't, let's say you see something in Japan or you see something in China and you think, well, I'm going to go come and patent it in South Africa. That's not how it works. It has to be a world first. So that is what we call an absolute novelty requirement. Then the second requirement is not only should your invention be new or novel, it should also be inventive. And what that means is basically it shouldn't be obvious. So I can't go and just make an obvious change to a known product, change the color or make it a little bit longer or add one additional simple step to a method and say I'm gonna patent this as my own. No, it has to be inventive. So it has to be novel and inventive. I'm not going to go into the third requirement now. Then there are certain types of inventions that are just not patentable. And again, we can go into a philosophical debate about it probably, but according to the laws of most countries, certain types of inventions are just not patentable. Even if it's the most novel and inventive invention in the world, it's not patentable. And probably the example that's the most easy to understand is a method of medical treatment. So in most countries around the world, you're not allowed to get a patent for a method of medical treatment. And the rationale behind it is fairly simple. You don't want to prevent doctors from saving people's lives because you have a patent on a method of medical treatment. And that's the reason why it's not patentable. So even if it's new, it's inventive, it's not patentable. Then I think from an ICT perspective, what's very important to understand is that a computer program per se, that means a computer program as such is not patentable. And why is that? The computer program as such, so a computer program on its own is not patentable because it's already protected by copyright. So when you create a new computer program, or an app, the software behind it is already protected by copyright. So you can't get a patent for that computer program, but what you can get a patent for in many cases is the method that you are using. So if you've developed an innovative new app, you can't necessarily get a patent for the code, but if you feel that the method that you're using, let's say this method of encrypting information, method of storing information, method of processing information, you believe that that is new and inventive, that can theoretically be patented. So that's a very important distinction to understand. It's quite technical, and it's something that I deal with almost on a weekly basis, is looking at things like new apps, new websites, new computer systems, and trying to figure out whether they are patented or not. Unfortunately, in South Africa, and I think most other countries across Africa, it's still a little bit of a gray area because we haven't really had many, or in fact, any court cases that I'm aware of where the court has given us guidance as to, when is something just a computer program or when is something patentable. So typically, what I tell inventors and clients is the more technical information you can bring. So the more technical innovations you've made, the better your chances are of getting a patent. So this is what the next slide for the benefit of those listening. I show on the screen a flying car, and that's a very nice way of explaining another type of thing that's not patentable. When I was talking about copyright, I said that you can't get copyright just for an idea that's in your head. And the same really applies to patents. So if you come to me and say, Hugo, I've got this idea for a car that can fly to the moon. Please register the patent for me. For the car that can fly to the moon, so that I've got a monopoly on it, I've got a patent, no one else can do it. So essentially, that's not enough for a patent. You can't just give me a statement of desired intent and patent that. In order to get a patent, you need to be able to explain how it works. You need to explain the technical elements of how it works. The fact that it can fly to the moon is great. That's a great advantage. But if you don't know how it's going to work, and if you can't prove how it's going to work, then you can't get a patent. And that's really relevant, again, in the ICT space, where I do deal with lots of inventors and people who come to us and say, we've got this idea for an app, and it's going to have these features. It's going to have feature A, B, C, and D. And we want to patent that. And then when I ask the question, how is it actually going to work to give me feature A, B, C, and D? And how is that different from what other people have done? Explain it to me on a technical level. Then that's where the idea sometimes falls flat, because you really need to give enough technical information. Because remember, I said that a patent is something or something. You need to give enough information for someone to actually go and replicate your invention in order to get a patent. So I think it's a nice example to remember. You can't patent a car that can fly to the moon unless you can explain how it's going to work. So I was saying that with patents, it's very important for the invention to be novel or new. And what we often do, and this is also something that members of the public, listeners, viewers, can do on their own time as well. Especially if you're looking to save costs, you can, before you decide on embarking on the patenting process or engaging with an attorney on it, you can go and do your own patent searches to go and see whether or at least get a fair idea of whether your invention is novel, or what your chances will be if you do file a patent application. And on the screen, I've got some examples of free patent databases. And one that I use on an almost daily basis is Google Patents. It's actually a very good free patent searching database. And I often tell clients and entrepreneurs, when they come to me with a new invention, I'll say, listen, go on Google Patents, go and spend a few hours and look around and see what you can find, because often people are not aware of what other people have tried to patent, especially in other countries, and that'll give you a good idea of whether it's worthwhile to go down the path of patent protection, or whether it's really not worthwhile because someone else has maybe done something very similar, even if it was in another country. And that's a really nice starting point, is to do so we call it a novelty search. Just go and have a look around, see what there is, get an idea of whether it's worthwhile to go the patenting route, or whether you're just barking up the wrong tree. It's not worth it. You should maybe focus your resources elsewhere. And in addition to novelty searches, there are also lots of other types of searches that you can do. And one of them is what we call a freedom to operate search. So that is where, if you plan to launch a new product or a new service into a country, you go and do a search to see if you have the freedom to operate. And what that means is whether or not there are any patents that might stand in your way. So that's typically a bit of a more complex exercise, but it's also a good idea to think about things like that. So just to give you an idea of how long your term of protection will be if you register your IP rights. Now, so most IP rights actually give you a very long term of protection. For patents, the general term of protection is 20 years. So from the filing date of your patent application, assuming your patent is valid and it gets granted, you can get a maximum of 20 years of protection on that. And for a design, it's either 10 or 15 years, depending on the type of application. And with a trademark, the nice thing is that the term of protection can be indefinite. So you can actually keep on renewing the trademark forever. And it makes sense if you think about products like Coca-Cola that have been around forever. You know, they've obviously been renewing the trademarks every 10 years for over 100 years. I don't know. I'm just guessing. But that's why, and I think I said it when I started talking, a trademark is often probably the most valuable asset that you have, because when you're starting up your business, let's say you've got a new startup in the software space, obviously when you're starting your business, what's very valuable to you would be your invention, you know, your patents and things like that. And they're going to give you this competitive edge. But over time, your trademark will probably outstrip the value of all of the other assets as your brand becomes more well known. For example, if you think about, you know, the most well-known sort of software or electronics companies in the world, Apple, Samsung, Huawei, Sony, you know, the value of the brand is much higher than the value of an individual patent or technology that they might have. So that's why it's very important, the fact that you can keep on renewing your trademark protection indefinitely. So it's also important just to understand what we call the fact that IP rights are territorial. So when I say IP rights are territorial, I mean that they typically only apply in a specific country. So there are some exceptions, but when you're dealing with things like patents, trademarks, designs, unfortunately, the reality is you'll have to register it in every country where you want to actually have that right and enforce it. Unfortunately, there's no such thing. It would have been great. It would have made my life a lot easier if there was something like a worldwide patent, or, you know, if you could just file one patent application and voila, you've got a patent all over the world. Unfortunately, it doesn't work like that, because, you know, each country has its own system, and ultimately you have to comply with the requirements of that country. But luckily, there are some regional systems that allow you to cover a bunch of countries in a single application. And for example, Europe, you can cover the whole of Europe with European trademark, European design, European patent. And the same goes for Africa, where there are two very good regional IP organizations. And one of them, I think the most relevant for today's talk, is called the REPO. That is the African Regional Intellectual Property Organization. So what is a REPO? A REPO is essentially a group of countries that came together and said that we want to create a mechanism to make it easier for our people and people from other countries to register their IP without having to go and file an application and spend so much money in each country. So at the moment with a REPO, and I file a lot of REPO applications, I find it a really great mechanism. You can cover up to 18 countries just by filing, you know, one patent application or one design application, for example. And the countries are listed on the screen, but you'll see that there are obviously some major countries there, like, you know, Kenya, Tanzania, Zimbabwe, some really, really major important countries. And unfortunately, it doesn't cover the whole of Africa. So, for example, South Africa is not a part of a REPO. Nigeria is also not a part of a REPO. But, I mean, it does help a lot to have a system like this where you don't have to go and register your trademark or your patent in each of those countries separately and pay separately each time. You can actually go through a REPO. And it's a really nice mechanism. And we actually find that a REPO, I think that they plan on keeping on growing. I heard the other day, I think it's correct, that Mauritius recently joined a REPO. And I think, over the next few years, we'll see more countries joining, and hopefully that organization will continue to grow and just make it easier for African innovators to register their IP rights. Now, we've talked about what is IP, how to register the different types of rights. So now we move to the more practical steps of how do you actually use this IP when you are commercializing your business and taking your business to the next level. So, and a lot of this is my opinion and from what I've seen in practice. So the first thing for me is IP should be a value driver. So it shouldn't be this sort of grudge purchase that you're paying attorneys to register trademarks, to register patents and pay renewal fees. You're paying all this money, but you're getting nothing in return. It shouldn't be like that. It should be a value driver. Your IP rights, so your patents, trademark designs, those things should be at the forefront of your business, should be your most valuable assets, or at least some of your most valuable assets, and you should use them in your business dealings, leverage them, and basically derive an income from them and get that strategic advantage so that it's no longer just this grudge purchase, you're just spending money. It becomes almost a profit center instead of a cost center in your business. And that's really what you're aiming at. Then obviously, IP should also strengthen your rights. So that's one of the main reasons why you want to register your IP right, is because it puts you in a stronger position. If someone copies you or launches an infringing product, launches a confusingly similar trademark, you want to be in a strong position so that you're able to take action against them, and you don't have to, go through all the effort of, for example, proving your reputation and things like that. Then what's very important for me, and this is really for me personally very important, just from what I've seen in practice, is that IP helps you to have a culture of innovation in your business. And again, if you think about companies that are very successful across the world, I've talked about companies like Apple, Samsung, and Huawei in the ICT space, but also in South Africa, many examples, companies like Sasol and Discovery. And those are companies that really take intellectual property rights very seriously. So they register patents, they register designs, they register their trademarks, they protect confidential information and know-how, and they create within their business and their employees and consultants, they create a culture of saying, we are an innovative company. We are at the forefront of technology. We are creative. We are, inventive. And that really helps to increase the value of your company, because a lot of it, as you would all know, is about perception. And it creates this real positive perception in the market. So now, for example, when you think about a company like Discovery or Apple, then what comes to mind is innovation, because they keep launching these new innovative products and features, and that's really where you want to be in the sort of business environment. You want to be at the forefront, and that all helps, especially for startups, actually, to make your business more attractive, not only to clients but also to investors. So if you're looking for someone to invest in your company, and I can almost promise this to you, especially in the software space these days, one of the first things that they'll be looking at is, what IP does this company have? What protection do they have in terms of registration? What do they do inside of their company to make sure that IP is identified, is protected? What culture do they have around IP? Is it important to them, or do they just have nothing in place and they just deal with it as it comes up? And that is, for investors these days, is critically important. I'm not going to talk about this next slide. On the next slide is a nice way of thinking about the whole IP management process, especially for entrepreneurs. So it's almost like a life cycle of different stages. And you've got basically 5 main stages. You've got creation, protection, assessment, exploitation, and enforcement. And these stages don't run sequentially necessarily, they can run in parallel. I mean, I can be creating new IP all the time. It's not necessarily just the first step in the process, but this gives you a nice overview for those of you who can see of this IP management process. So obviously, when you're starting out as an entrepreneur, you would be doing research and development. You're busy developing your product, you're developing your brand, you are creating your software, and all of that, those things. And what's important at that stage is making sure that you own the IP. And I'll touch on that later. Making sure that it's in the hands of the correct person or entity. And then obviously once it's been created, you need to register it and protect it. And that's what we've been talking about on the previous section. And that's the protection stage. But it's not only about IP protection. You also at the same time need to think about other forms of protection that you need to put in place, like regulatory. For example, if you've got a new app, you need to make sure that you comply with all the data protection rules and privacy rules. You need to get your terms and conditions in place. So that's all part of the protection stage. And then as your business grows, you get to the assessment stage, where you're almost like doing an audit on your IP to see, this is what we have. These are the rights that we have. This is maybe where we've got some gaps. So for example, we've got a few products and we need to register the trademarks. And you need to, then it really becomes a management process. You need to start managing your IP in the correct way. And then the next stage is exploitation. And that's hopefully where you start making money and your IP is involved in that whole process. So whether that is because you are licensing your patents to other people, whether you are using your trademark registrations, whether you have a joint venture with another company and your contribution is the IP, whatever the case may be, you are exploiting your IP and hopefully you're now extracting value from the process. So now all of the investment that you made up front is hopefully giving you some sort of return. And then you also need to manage the process very carefully. And then it becomes more sophisticated where you start looking at things like IP valuations, trying to put a value on your IP, trying to structure your business correctly to make sure that the IP sits in the correct place. And all of those things are very important. And then the last phase is enforcement. So that is where, someone is infringing your rights. Someone is either copying you or they're doing something that's too similar. They're basically falling in the scope of your rights. And now you need to enforce. So now you need to use your IP as a stick against them. And those are the phases in this whole life cycle of IP. And it's very important, as I said, not necessarily sequential. So for example, while I'm enforcing my rights, I'm still creating new rights. I'm still creating new inventions, new trademarks, and I'm registering those. So all of these 5 processes they're almost intertwined and they're happening at the same time. And you need to make sure that you manage them correctly. Then I know, and this is very important, and it's also a tricky topic, and that is the whole issue of costs. Because the perception, rightly or wrongly, the perception on the African continent is that it's too expensive to register patents and register trademarks. We don't have the money. We need to spend our money on other resources. So that, and obviously cost can be an issue, but we need to think about it in the right way. So the first thing is that you shouldn't think about it as a grudge purchase. You should almost think about it as an essential asset. So you should think about it as almost like insurance. You need to sort out the things up front. If you don't do it, it'll really come back to bite you. So that's the first thing, is you need to change your mentality about cost center versus profit center. And the second thing is you need to be strategic about how you spend money on IP. And the IP system already has the mechanisms in place to allow you to do that. So the example that I've got on the screen is for patents and how to make sure that you can protect your invention strategically. So what you want to do is, let's say you're a startup company, you've just came up with a new invention and it's really great and there's a lot of potential in it. Obviously, you don't have the funds to go and register this patent in 50 countries around the world. It's not feasible. It's not possible for you to do that. But luckily, the patent system, and this is true for most forms of IP rights, already has mechanisms in place for you to get around that problem. So what you typically do, and I'm using South Africa as an example, is you would file a provisional or temporary patent application in South Africa. So just the one application, and that would give you 12 months of temporary protection worldwide. So now you've got 12 months to basically hustle and try and get this invention into a commercial form and market it to the public and get distribution channels going. And then hopefully at the end of the 12-month period, you have either got an investment or you've got a good idea of where you want to protect. If not, there's another mechanism known as the PCT, Patent Cooperation Treaty, whereby you can extend the 12-month period by another 18 months. And what that gives you is 30 months in total before you have to go and file your individual patent applications in all of the countries of interest. So that's what I'm trying to say when I say be strategic about it. You want to get to a point where at the end of this 30-month period, you are actually getting an income from your business and your invention is now working for you. And then hopefully you do have the budget to be able to pay for patent applications in various countries. So it's all about being strategic and doing the best you can with what you have. And I really think that it's doable in the African continent to get it done, and we see it being done every day. But then obviously the reality is sometimes the funding is just not available. I mean, that is the reality of the situation. Sometimes you just don't have the funding available to get those registrations. And then you have to be almost even more savvy and more strategic about it. Then you need to start thinking about things like, is it possible for me to keep my invention secret? You know, can I exploit my invention but keep it as a trade secret? So even though I don't have a patent, it's still not possible for anyone to copy me. Obviously, that's not always possible because some inventions can be reverse engineered. People can see them and copy them. But in some cases, it's possible. For trademarks, if you don't have a registration, there are still ways that you can enforce your trademark rights. So what I'm trying to say is it's not the end of the world if you can't get those registrations up front. It's really ideal to do so. But there are still ways and laws and mechanisms available to help you. And at the bottom of the slide, it says that different companies adopt different strategies. You need to adopt a strategy that works for you and that is feasible for you. Obviously, the strategy of Apple will be different to a strategy of a startup inventor in Cape Town. You know, that's just the reality of the situation, and you need to be smart about it. Then I said, I think I don't have too many slides left, but this is a very important slide. And for the benefit of the listeners, what I want to touch on for a few minutes is the issue of IP ownership. So IP is an asset, and you need to make sure that you own it. And there are two very big misconceptions out there in the public. And the first one is, I own it because I paid for it. And the second one is, I own it because I created it. Both of those two things can be true, but it's not always true. So the first one is, there's this misconception that, you know, we paid for the IP, we paid for someone to develop something for us, so obviously we own it. That is not necessarily always true. So to use a topical example in the ICT space, obviously when you use a third-party software developer to develop software for you, it's very important for you to own the copyright in that code. And the South African Copyright Act actually says the owner of the copyright is the person who exercised control over the creation of the copyright. It doesn't say the person who paid for it owns it. It says the person who exercised control over the making of the software owns it. So what does that mean? It means that if you're not exercising control, you need to make sure that the contract says that that person is assigning the copyright to you. So just because you paid for it doesn't necessarily mean that you own the IP. make sure that your contract with the software developer says in writing all of the copyright, all the other forms of IP that may be relevant are assigned to you. And that's the way, very easy way to get around the problem. But it's not so easy if you wait 5 years and then try to sort it out, because then it might have become a very successful product, and now the software developer also wants a piece of the pie. So very, very important to make sure in writing that you own the IP, even if you paid for it. Then the second misconception is, as I said, I created it, so I own it. Again, it's not always the case. So I may have created software, I may have written the code, but I wasn't exercising control, but it was my manager who was exercising control, or I created a new invention for my employer. In cases like that, it would actually be the employer who owns the IP and not me in my personal capacity. So the whole issue of IP ownership is very important. And again, this is probably one of the first things that any investor looks at these days. When you are an investor and you're doing your due diligence on a company, you're looking to invest, what are you going to look at? What IP does the company have? And do they actually own the IP? And that's where they really start looking at these contracts to make sure, and I'm involved in it probably on a weekly basis, where we need to look at these contracts and make sure that the company we're looking at does actually own the IP. So it might sound complicated and doom and gloom, but it's actually quite simple. Just make sure upfront that your contract with whoever you're working with ensures that the IP is assigned to the correct party. It's really something that can be sorted out fairly easily upfront. And that brings me to the whole issue of contracts with third parties. So obviously, if you're an entrepreneur, especially again in the software space, but also in other spaces, it's almost natural that you'll be working with third parties, working with software developers, working with marketing agencies, working with designers, product designers. And again, it's something that you need to sort out upfront. So when you start talking to these third parties, when you start negotiating contracts, think about IP. What IP will be developed? Will it be software? Will it be trademarks? New product designs? Could there possibly be patents, some patentable inventions? Think about that, and think about who is the entity that we want to have ownership of those rights, and deal with it up front. Don't wait 3 or 4 or 5 years and say, oh, now we actually want to register a trademark, or we want to patent this technology, and then you never actually dealt with the issue of ownership. I'm not going to deal with the rest of it. I think it goes without saying that you need to make proper use of things like confidentiality. I think most people listening and viewing would have a good grasp of the fact that confidentiality is very important, especially for patents and designs, because you've got this novelty requirement. So that means as soon as the invention is out there, it's out there. It's typically almost impossible to go and register a patent after the fact. So you need to make sure that before you've actually filed a patent application, you need to be talking to people confidentially. It has to be strictly confidential, because if it's in the public domain, it's out there and you can lose your rights. Then I think this is my last slide, just with some sort of general tips that I really want to give to the listeners and the viewers. As I said earlier, obviously, as an IP attorney, I would strongly advise to get IP registrations if you can, but it's not always possible, and we need to be realistic about it. Then you need to make good use of things like non-disclosure agreements. It can be very simple, just to make sure that your engagements with third parties are confidential. Don't forget about your know-how. I think I've touched on it a few times during the talk, but know-how can be an extremely, extremely valuable part of a business. Just as an example, let's consider a business like KFC or McDonald's. They don't necessarily have things like massively innovative technology or patents or registered designs what the value that they really have in the business is the know-how. So they have a specific way of doing things, and a lot of it is secret, and that's why I've got the KFC logo there, because of the secret 7 herbs and spices. A lot of it is secret. They don't disclose it to the public. They make sure that it's internal to them. And when if I want to buy into that business, or if I want to get a franchise, what am I paying for? I'm actually paying for the right to use that IP. I'm paying them because they've got this know-how, they've got these secrets, these great business processes that they've developed over years, and that has so much value. And that's what I'm trying to say is really take care of your know-how, because that can be the thing that gives you a competitive edge. Is not necessarily your patents or trademark, can be something like your know-how. And then keep it secret if you can, but obviously it's not always possible. I think, Martha, that's it from my presentation's perspective. I'm happy to discuss further with you, or anyone has any questions, I'm happy to talk through them as well.
Okay. All right. Thank you so much, Hugo, for a great presentation. To those who just tuned in, this is Martha Matsarenda Shumba, creating the Africa we want. And we're with Hugo here talking about IP and trademarks, copyrights, patents, registered designs, and let me do this. Okay, I think we are good now. Let's do this. And I believe a lot of people here actually learned a lot. I see that, okay, I wanted to get something here. I see from General Eric Knight, who's also the founder of Radio 54, his comment is, I hope musicians, especially from Mother Africa, get to listen to this. Music is intellectual property, and they need to know their rights and maximize. So when it comes to musicians and their songs, how do they get that protected? How should they do it? What's the channels to follow?
No, thanks, Martha, and thanks, Eric. That's a very good point. And music would be one of the good examples of things that falls under copyright protection. So if you create a new song, you write a new song.
Okay.
Can you hear me, Martha? Martha, can you hear me?
Yes, I can hear you.
Yes. Yeah, so music would be something that is protected by copyright. So that would be one of the things.
Yes, can hear
from South
you.
African perspective, that is a right that comes into existence automatically. So typically, music rights are dealt with, between all of the various role players in the music industry. And as an artist, especially as an independent artist, it's very important to know your rights and to know that you are the owner of certain copyright and intellectual property rights. And if people want to exploit your rights, so in other words, if they want to play your songs or play adaptations of your songs, you are entitled to royalties. You are entitled to an income from that. I myself, I'm not a music rights expert, but just in basic terms, that is very important. Obviously, if you're sort of a big artist with a record label, that would be dealt with by your management. But as an independent artist, it's very important that if you created a song, you have those music rights, those intellectual property rights. The third party can't just come and exploit that. you are entitled to remuneration, and it's not like a patent or a trademark or a design that you actually have to register. Those rights exist automatically. So it's really important that you assert your rights and that you make sure that you do extract the value and get the return on the investment that you made by creating and being creative.
I see Mother has disappeared. Do you guys see her from your screens?
No. I think it's been cut off. A signal, there was an echo, and there was a delay message.
Okay, maybe while we wait for her, Sonwabo, maybe from Paikta's side, I mean, from an IP perspective, what are some of the trends, the things that you are seeing, and maybe some of the things that you are concerned about in your dealings? I know you guys deal with a lot of innovative people, especially in your hackathons. What are some of the comments that you'd like to make on this topic?
It's like you've read my mind. I was just about to ask you about hackathons and them, because you bring along together a young lads or youth to come and code. Listening to you, it sounds like the IP is from the creator, then unless it's assigned. Can we assign, when we create a hackathon, can we ask them in advance before they create or any IP? Can we ask them to assign that to ourselves or partially assign, because some of them we want to develop them to startups?
Yeah, there's no one right or wrong answer, and there's many ways to deal with it. But what is important, I think, is to deal with it up front. So before someone takes part in a hackathon, for example, it's important for everyone to be on the same page and to understand. Okay. For example, if let's say I take part in a hackathon and I create some new software, who owns that? Do I get to keep it? Do I get to be the sole owner? Or by taking part in this hackathon, am I assigning my rights to Paekta or to whatever organization? And there are ways of sort of meeting each other in the middle. It's typically not a good idea to share ownership of IP. It makes things a little bit too complicated. But what you can, for example, do is, let's say your organization does take ownership of the rights, you can still give the creator a license to continue to use those rights, or, for example, to continue to build on it if they do want to make improvements. But I think it is important for everyone to be on the same page and to understand that by taking part in an event, for example, I might lose some of my rights, or whatever the case may be. But that is what I would suggest. It would depend on, I guess it would depend on whether your organization actually wants any interest in that IP.
Okay. Let's say Hugo, you've got guys that have got an IP, which let's say they've gone through a hackathon from an idea to conceptualization to prototype. Okay, they've got a working prototype, but that's where it ends, because that's where the hackathon left the process. Now, without an intervention from anyone, it will never go to MVP and to the commercial level. Organization out there, I understand, and I'm not going to mention names, when they come in to take that working prototype to MVP and commercialize the IP, they actually take a percentage of that IP. They take ownership, a percentage, which you're saying now. It's not easy. It can be untidy, basically co-owning the IP. But the individual or entrepreneurs that have come up with an idea, they might never be able to develop that idea or that IP. Where do you stop? Do you stop and sit with the idea that you've created and sleep over it? or do you take it and lose a percentage of it? And that's the only way you're going to make money out of it?
Yeah, that's I hear you, Sonwabo, and obviously that is so difficult for startups. It's such a difficult terrain to navigate. So what typically is a good idea is to deal with the ownership more at the company level than at the IP level. So, for example, you can leave the IP ownership to the guys who created the prototype, but the investor can take a stake in the company itself. So, for example, you can give the company some investors some shares in the company, and there would be certain strings attached to that, and that would give these guys, a cash injection or an investment to enable them to actually take it further. Because, as you say, you need someone to partake in this journey with you. Otherwise, you will never be able to take it further. So you just need to make sure that everyone is equally happy or equally unhappy with the arrangement. You need to meet each other in the middle, somewhere that makes sense. And what usually makes sense is allow the innovative people to be innovative. Allow them to go from prototype and get it into the market, and support them maybe more from the company side, if that makes sense. Because once you start splitting up the ownership of the actual IP, it can become extremely messy.
Okay.
Okay, I have a question here, Hugo. I hope you hear me now. Can someone register a trademark that have Africa? Let's just say Kulula Africa. Is it something that is possible using Africa when you want to register something?
So it's a good question, and it comes down to the basic principle that the trademark has to be distinctive. So let's say Kulula, the example of Kulula Africa, that would probably not be registrable as a trademark unless maybe the company Kulula actually registers it as another trademark for their company. So I can't, let's say the company Nike already exists. I won't be able to register Nike Africa because that would actually be very confusing to the public. Because if someone saw that trademark, they would think that it's associated with Nike. So typically, just adding the word Africa to something won't be enough. You need something that's very distinctive. You need, and you also always have to think about it through the eyes of a consumer. If a consumer looks at the product, would they be confused? Would they be like, "Ooh, is this Kulula Africa? Is it the same company? Is it two different companies?" And if that confusion arises, then typically you've got a problem.
Oh, okay. All right. Thank you for that. And what about people who want to use their names? For example, Martha. I want to check Martha. Is it something that I want to use it as a name of a company or for a product and so forth? Would that be allowed, or it will erase every other person called Martha who's gonna be born?
No,
Can I say something?
Dominique?
Martha, just look at what ENS Africa means. What the E and N means.
Okay.
Yeah, so no, it's a good question, Martha, and there are some very good examples of people whose names have been registered. Think about my namesake, Hugo Boss, or Calvin Klein, or Jenny Button. Those are all. There's so many names, but from a trademark registration perspective, it's probably very difficult to get it registered. So, for example, Martha, it would probably be difficult to get it registered because it's not really distinctive. But if you are able to gain a reputation, and that's what I said earlier. So if Hugo Boss, obviously, or Calvin Klein, they've gained such a massive reputation in that name that they are able to claim protection for that. But it's typically very difficult to just stop other people from using their own name. So if someone coincidentally has the same name, I think it'd be quite difficult to stop them. But to answer your question, yes, I mean, as long as it's distinctive, as long as And if you've got a reputation, yes, you can register.
Okay. All right. Thank you. Thank you so much for that.
Okay,
Okay,
I
you can go
have
on.
my own. Okay, I have my own question, or maybe should I call it a concern? Where in this industry, working with startups, I have actually. Can you guys hear me properly?
Yes, we can hear you. There's some chatter in the background.
All right.
Okay,
Well, I'm
done.
alone here, so it's the network. Okay, I was saying, I've come across companies, new startups, who are actually providing services that are already in the market. So they're creating apps. So you find that in 2019 alone, I came across three ladies. All of them had created this beauty on demand app where you order a nail technician, a hairdresser, they come to your house and then they help you with those services. It's a very good concept, but it's not new in the world. It already exists in other continents. Now, here in South Africa, they're like, oh no, I'm the first one to do this. I'm at an event. The following week, I'm at another event. I meet exactly I meet someone with exactly the same concept. And now they didn't know each other and they didn't know that they existed and they were all looking for my services. When I went online, I discovered that there's a girl in Pretoria who's already developed the same app offering the same services. So now there was conflict because this one is saying, the other one actually has a lot of media coverage saying first ever female entrepreneur to develop this app that brings beauty to your home, to your office, and all that. So in that situation, how does the law protect their intellectual property if it's the same and it's not new? Would they have problems in doing business in future? Because we look at it like we are seeing a lot of food deliveries, a lot of companies like Uber that have also come up even after Uber launched and it was the first one. Airbnb, it's like everybody's just copying the same idea, the same business style, or maybe know how, and then bringing it to start something new altogether. And it's working, they're in business.
Yeah, it's a very good question, Minnie, and I agree that it is working. So there's two perspectives to look at. The one is, are you stepping on someone else's toes? So are you infringing someone else's rights? And on the other side of things, can you, what protection do you have? Can you register your own rights? So if you want to know, let's say the beauty startup, or let's use the Uber example. I think it's a nice example. There are obviously lots of other companies like Bolt and Taxify and whatever you offering the same sort of service. So are they stepping on any toes? You would need to look at it from all of the different IP rights. So from a trademark perspective, probably not. They're using their own trademarks. It's not confusingly similar to Uber. From a copyright perspective, as long as they've created their own software, their own code, their own user interfaces, they haven't copied anything from Uber, then they're probably fine from that perspective as well. From a patent perspective, they probably could run into some problems if Uber, for example, does have some patents in South Africa that give them a monopoly on some of their processes that they use. So it is possible that they could step on Uber's toes there. But remember, very important is that a business method is not really something that's protectable by way of IP. So the law is very clear that people need to be able to do business. As long as they're not doing business in an unfair way, as long as there's no unfair competition, you need to allow people to do business. And you don't want people to monopolize the market. You don't want Uber to have 100% of the market, for example. So if they typically allowed to use a similar business concept, as long as they don't infringe the trademark or infringe the copyright or infringe any of the patents, they probably okay. But it is a difficult question. And then from the other perspective, where you look at can I register? Let's say I've launched my own version of Uber or my own version of the beauty app. What rights can I register? Again, you could look at registering an innovative brand. You can come up with a very distinctive brand. So even though the service or the business model is known, you can still come up with a very innovative or a striking or a distinctive brand that can be registered and give you some rights in your brand. But you would probably not be able to, get a patent or get registrations like that because the concept is so well known. So I think it's one of those almost gray areas where it's always something that's going to happen when there's a new technology. You're going to see people, especially many, and I think it's a very good example, this on-demand whole craze of everything being, you can order anything on an app. So obviously people are going to come up with an idea to order food, to order beauty, to do transport everything's now on demand. And you need to make sure that you don't infringe people's rights, but it's also difficult because sometimes you don't know about, so for example, you could launch a product, for example, sued by Uber or patent infringement, but maybe you weren't even aware of that patent. So it's a difficult landscape to navigate, and you need to do your homework to the extent that you can. Obviously, if you're a startup company, you don't have a lot of funds. You don't have 100,000 or 200,000 rand to spend on attorneys to go and do investigations for you to see if you're going to infringe on anyone's rights. So you need to be pragmatic and practical about it, and you need to deal with the low-hanging fruit. So there are certain obvious things that you can prevent. And I guess the most obvious one is don't use other people's trademarks. Don't use confusingly similar trademarks. That is one of the easiest, more obvious things that you can do to make sure that you don't infringe. When you get into things like patents, it's obviously more complicated because it gets a lot more technical as to what patents do they have, what technologies. I hope it answers your question, but it's a difficult one, but a good question.
Okay.
Yes, thank you.
Okay, you can go on, Minnie. I was about to say Minnie.
I'm good. Thank you, Hugo.
Okay, I have a question here coming from Eric. Eric Knight is saying, can you ask Hugo for me concerning music in particular? Can anyone claim ownership or copyright if it's purely instrumental music? For example, if the sound is purely African drums and no words or lyrics.
Yes, so I'd have to look at the specific example, but don't hold me to it. But the general principle of copyright is if it's original and if it's reduced to material form, then it can have copyright protection. So if it's just African drum beats, but it's an original beat and it's your own creation that you've come up with and you've put it into material form. So either you've written down the notes or the beat or you've made a recording of it, then yes, I think that would qualify for copyright protection, even if there's no lyrics. Maybe someone else comes around and creates lyrics after the fact, and that could be a separate thing with its own separate copyright as well.
Okay, I'm glad that is also answered. And I have Abdul here who is asking, can you share the presentation? Or people will be busy here stealing there.
Now I'll find out from my organization and I'll chat to Pipeta as well, and I will let you know. And Martha, I assume you have your channels through which you can make it available, but I'm sure we can share something with the audience, even if it's not the full presentation, maybe just the salient points you can share with the audience.
Okay, what I can also need from you, I'll send you an email so that you can have anything in Word document that we can also put on the website if that's okay with your organization. And also this is live on Facebook and on YouTube. So the presentation that you already did is still gonna be there with the whole conversation.
Perfect.
Well, I have another question. I'm looking for it. All right. In terms of pricing, if somebody have to register a logo, how much would that cost if it is to cover only South Africa?
Yeah, if it covers only South Africa, it would depend on. So when you file a trademark application, you need to file it in one or more classes. So I think, if I remember correctly, there are 45 classes, and so covering different goods or services. So you need to register it in. If it's only relevant to one class, you'll only register it in one class. So let's say you've only got one class of interest, then you're probably looking at around, I would say, 5,000 Rand to get it done properly for you. It's one of those things, and the same comment applies to provisional patents. You can probably go and file it yourself at the CIPC for 50 Rand or 100 Rand, but it's one of those things where, and I'm not just saying it because I'm an attorney, if it wasn't done by a professional person, it probably has very little value. Because it's such a specialized field and such a complex field, what we see is people who go, and this is with all due respect, obviously, to people who go and try and register their own patent application, for example. If you don't really have the expertise, or you don't really know what to include, what not to include, what limitations, then it typically doesn't really have much value, and it won't really stand you in good stead. You won't really be able to enforce it. So my advice would be try to go through a professional if you can. Obviously, if you can't, that's the reality. Then you can go and try and register it yourself. But that for me should be really a last resort. And again, I'm not saying it because I want to make money. I'm saying it in the best interest of the listeners.
Okay. All right. No, that's fine. So let's just say, for instance, someone have this idea written on paper, already executed, and is adopted by the government. How do you protect that or follow up to maybe sue them?
Do you want to drag the government into this?
I'm asking this question because we have a lot of young people who have done that, and they've cried for play to say, you see what they are doing or what they've implemented. It's actually my idea, copied and pasted, including the images, including the logos.
Yeah, it's a good question, and you can look at it from different angles. So not only from an IP angle, but also from a general law angle, looking at it as unlawful competition. So the first thing you need to establish, and it's something we see a lot, I deal with it almost on a weekly basis. The first thing you need to establish is, what rights do I have? So is it copyright? Is it an invention? Was it confidential information? So what rights do I have? So let's say it was a presentation that you confidentially shared with someone to pitch it to them, and it was very clear that it was confidential, and that presentation is copied exactly by this third party, even the images and the words. Then you probably have a very good case for copyright infringement. It sounds to me like there's copyright infringement. Sometimes there's no pure IP infringement, but it could still be seen as unlawful competition if someone takes your idea and tries to profit from it. But Martha, it's something we see a lot, and it's very difficult to deal with, especially when you have a David versus Goliath situation where you've got a small startup person or an inventor, and you have to go up against a large organization with deep pockets and attorneys. So in many of those cases, you probably do have rights, but you also need to decide, is it worth it to go after these people? Is it going to be worth the cost? What am I going to get out of it? And so that's the one thing. And another thing that we're seeing more and more, almost on a daily basis, is the power of social media. It's something I haven't really touched on today, but maybe let me just talk about that for a minute or two. So in the past, before social media, I think the consumer or the small guy was probably in a more tricky position, almost powerless in many situations. But with the rise of social media, we're really seeing that big organizations are very frightened of social media, even more frightened than IP rights in many cases. So we've seen, and I'm not going to mention any names, but we've seen over the past few years big organizations in South Africa and abroad who have, removed products from their shelves or retracted statements or changed their trademarks because of social media backlash. And so that is irrespective of whether they were right or wrong. And that's a difficult thing with social media. Often it's not like the court. It doesn't often people don't really care who's right and who's wrong. But so organizations are extremely hesitant and they pay attention to what's being said on social media. And it's also very important to bear in mind that you need to be very careful as to how you deal with people's IP. Because if you deal with their IP in an maybe unlawful or morally incorrect way, you could really burn your fingers on social media. And the impact that it can have on your social media profile or reputation can be in many cases even worse than the legal implications. So that's something I just thought I'd say as well. And it's important for everyone to bear in mind, not just big companies, but also even if you're an individual, just bear in mind that social media is very powerful. And you don't want someone making claims against you on social media, even if they're not true. You don't want someone making those claims against you because it can really hurt you.
Okay. All right. Thank you so much for that. I wanted to refer to something here. We have this case of Kosana Mahate, the guy who proposed the please call me concept to Vodacom, right? I think it's an ongoing case and not really into discussing the case per se. But in situations where somebody is working for a company and they propose something when they were an employee, and this thing become massive, like the please call me. Can they really stand a chance? Just looking at what you said, that will they win the case going against such big corporates? Or how can they sign? What documents can they sign when they are working for the company to say, should this go, big, I need some percentage?
Yeah, it's a good question. And the please call me one is very tricky. And that's why it's been going on for so long. And I think the main reason is not really an IP dispute. It's more of a contractual dispute. I'm not very familiar. Actually, I've never read the case, just to be clear. But I think what happened there, it's not a dispute about intellectual property. It's a dispute about what was promised to him contractually. So I think that's why the dispute has been going on so long. But you raise a very good point. So typically the general rule is if you're employed to do a specific thing, if you develop a new invention that falls within that scope, it's owned fully by your company. But I think in the please call me case, the inventor was probably not. I think was he employed as a security guard, or because he was not employed to come up with new inventions like that. So I think that even makes it more tricky as to who is entitled to what. But the general position is, let's say I'm employed as a software developer. If I develop software during my employment, it's owned fully by the company. That's the general rule. And if I want some sort of benefit, I need to contract out of it. I need to. So maybe the advice that I would give the person in that position is, before you disclose this invention or idea to whoever, whether it's your employer or the third party, this idea that falls outside of the scope of what you normally do, put something in place in writing as to how is this going to work. Obviously, in the case of Vodacom, it was Vodacom who brought all the resources. It was their resources that were required to make it work. But then what benefit would the inventor get in exchange for that? So, and I think that's also the problem there. It was never fleshed out in any detail as to what is the arrangement. Vodacom develops it and brings the resources, but what does the inventor get in return? So my advice would be, as I said during the talk, deal with the stuff up front. Because if you, and this is a very good example, Vodacom case, if you try to deal with it afterwards, once it has become a multi-billion rand dispute, then it's extremely problematic, extremely problematic.
Yeah, that's something, because I realize that a lot of young people are innovative and they go with the excitement and passion, but they give all the information out there without even thinking. And I think during the induction period in any company, it should be a rule for the company in the contract, or some sort of training to be undertaken to say this is what you are going to do specifically, and anything else that does not fall on this contract, you need to bill us. I know that doesn't work well with employers, because they need to benefit from whatever innovation you can come up with.
Yeah, but it's a good point that you raise. I think, Martha, there is a lack of IP training and IP awareness, and I think it's true across the world. It's not only in Africa. People need to be aware of how it works. You need to be, if I create something in the course of my employment, it belongs to my employer. If it's outside, how does it work? What are the arrangements there? Because I think in many cases people just don't know, and then they go too far down the path, and then it's too late. But it is very tricky, because if you're a small startup and you're pitching an idea to someone, you need to basically tell them the idea. Otherwise, how would they know if they're interested or not? So all you can do is you need to put yourself in the strongest position possible. You need to be realistic as well. You need to do what you can do with the resources you have, and because you don't want to just say I'm going to go to court, or as we've all seen that it's not easy to go down that route.
Okay, all right. I have Lesejo here who is asking me a question. I would like to know how the status of the patent bill, when is it going to be made available to the public?
I assume the question is about the new Patents Act. So there's a new patent law in the pipeline. We understand from the government, the CIPC, and the Department of Trade and Industry. The answer is we don't know. We know that there are some plans to amend some of the patent laws to bring in some changes and some new provisions. But as far as I'm aware, I'm not part of the government, so I can only say as far as what I've heard from the outside is it's still in progress. I think it's reasonable to say that it will still be some time, and then obviously they will publish a new bill, and then it will be open for comment and questions, and issues can be raised before it actually becomes an act. But I do think it's a valid point. I think within the next, I don't know, maybe 5 or 10 years, we'll probably see some new patent laws in South Africa.
Okay, that's great stuff, and thank you so much for taking the time to do this presentation and sharing with the public. I see there's a lot of interest on this topic, and I believe that it will also be great to have you when it's implemented, the new act, for you to come back and actually explain it. When they put these acts, bills, and laws in places, it's just out there on their platform, but not really communicated to the rest of the public. Let's talk social media, where everybody have access to it. There are people who are, graduating from colleges, from varsity, starting their own businesses. They are not aware of these things or where to even look for these things. I know it is an individual duty for you to look for that information. And I would also like to know where your organization, ENS Africa, How do you also get the information out there? Social media pages, or do you do workshops? Do you travel around Africa to create awareness?
Yeah, that's a good point, Martha. And I think it's very important because often there can be a change in the laws, copyright laws, patent laws, and it can have an impact on me as a member of the public, as a person on the street, but I don't even know about it. I didn't even know it changed. I didn't have an opportunity to provide comment. And there is a responsibility, I think, not only on the government, but also on other organizations like law firms to assist with that. And we try, I mean, through our channels, we try, or through social media and presentations and forums, we try to raise awareness and make people aware of bills that are open for comment or proposed new rules. And I think it's a good point. I think we do what we can. I guess we can always do more because it has an impact on people and they don't even know that it's going to change.
Okay.
I think, can I say something, Martha?
Yes.
I think looking at the interest that people have on the topic between Beetroot and Piter and yourselves, right now, your listeners, what they want. I think it's a question that you must ask. Would they like us to have a follow-up, maybe having Hugo from a legal perspective, and maybe bring one person from another institution or organization and government? It will be important to have government to sit so that whatever that Hugo can commit, government as the people that own the policies, they must be forthcoming and be able to guide, especially that South Africa has not really joined the other African countries that, as Hugo has presented. I think also we need to do a comparison that what's the difference between the South African IP protection, your copyright, your patent, your design related, to all other African countries that are out there, especially the ones that have formed an organization, they've come together. Are we similar in terms of our laws? Are we totally different? And this, I think, the next run, Hugo, maybe it's going to focus entirely on technology. It will be good to focus on technology and cover that extensively, as we see Africa as a continent that is going to be spearheading or trying to spearhead innovation in the continent. It will be very important, as we trying to drive Africa or Africans to be able to be exporters rather than importers of technology right now. Right now, we are importers. At some point, for sustainability and growth, we need to be exporters of technology. And if you push the youth to go that route, how can we protect them while they are still, teach them these things while they're still at high school, take them through university or TVET colleges? By the time they finish, they know exactly what needs to be done and how it has to be done.
Okay. No, thank you so much, Sonabo. I'll definitely do a follow up on this because we introduced this topic, and it's the first time that we've spoken about this, and it is a lot of interest. People getting interested in knowing all of this. So it will also be great to invite somebody from the government so they can also explain their political side of things, and everybody else involved in making sure that these acts are implemented in favor of us. Because usually when they come up with this, if we don't give any input, it's never in favor of us, by the way. So anyway, thank you so much. And I think we're left with just a few minutes to close off. Hugo, if people want to get in touch with you, individuals, organizations who wants to take advantage of what your organization offers, How do they get in touch with you? And also a second question is, I see that you are a senior associate in the intellectual property department. What did you study, and what did you study to be where you are, to be able to be a patent attorney? What exactly was your focus?
Okay, yeah, thanks, Martha. Yeah, I'm happy for people to contact me. My email address, I think, is on the shared screen. I'm happy for you to share that with the viewers and listeners as well. And obviously, if I can't assist with the specific query, I can refer them to someone else. We're a big organization. We all have our own specializations. Yeah, so in terms of the patent attorney qualification, it differs a little bit from country to country as to what you need to become a patent attorney. But in South Africa, you need a technical qualification and a legal qualification. So I have an engineering degree and a law degree, and then I went through the normal sort of. So you become almost a legal specialist and a technical generalist. So you become less of an engineer, but you still have a little bit of grounding in engineering. And I think and some of my colleagues have other technical qualifications like BScs in biotechnology or things like that. But I think for a patent attorney, it's important to have some sort of technical background because we deal with a lot of new technologies and invent just to have a grasp of what people are talking about so that it's not completely foreign to us when someone comes to us with a new invention. Very interesting field. Obviously, we deal with lots of new inventions, and it's almost it's a bit nicer side of law because we don't deal with criminal cases or the nasty stuff. It's almost a bit more exciting because we deal with people's new technologies and they're very excited, and we really try to help them just to protect it to the maximum extent. And Yason Wabo, I agree with your suggestions. I'm happy to do a follow-up session. I think it's always nice to get input from the government to hear about the plans and the directions that they want to take the country in, because as you say, they take ownership of the policy. So it's always good to understand the policy direction and what they have in mind for the next 5 to 10 years. And I agree that it would be nice to discuss the different IP systems across Africa and maybe compare them, because I think my personal view is that it would be good for all countries to be as similar as possible across the world. It would be good for the requirements to be almost universal. And I think it is moving in that direction across the world. The requirements that I talked about with patents, things like novelty, inventiveness, most of the countries around the world are adopting the same standards, but I think it has a long way to go. Hopefully, in the next 10 or 20 years, we do see a lot more progress where countries can work together and really make it accessible to every person, everyone with innovation, accessible to them to be able to get that protection, and not only accessible to big corporations. I think that would be great. So happy to do that. Sounds good.
Okay, I think it's very important that we have something similar, so that if I register a patent or trademark here in South Africa, and should I go to Tanzania to run the same product or a company, I'll just do the necessary that needs to be done in that country, but I don't have to go a different route or a different process for me to be registered. I think I have another question coming before we close off. All right, this is Alex who is asking here: is registering patent rights the same as registering an ordinary company?
No. So the answer would be no. So registration of companies is, at least in South Africa and in most other places, it's a completely separate process. So if you want, and the same goes for website domains, right? So if you have a company and you've come up with a nice new name, the company registration, the trademark registration, domain would be separate processes. but it's important to coordinate them because, of course, you don't want someone else to maybe have the domain name and you have the trademark and the third person has a company name. So it's very important to coordinate all of that. I would say that the company and domain side of it is a bit more simple than IP, bit easier to get that registered. But it's a very good point that he actually makes. So just because you've registered, for example, a trademark, it doesn't mean that you've got the company name as well. So yeah, thanks for that.
All right. Thank you so much, Alex. I think you got the response from Hugo. It's quite interesting that this interest in the patents and so forth, but people never have this conversation. Thank you so much, Sonwabo, and I would like to close off, I think, in the next 5 minutes or so. So would want to have any closing remarks from all of you. I'll start with Sonwabo.
Okay, thank you, Martha. I think for people who are listening, PICTA is a fairly new organization. We've been around for less than a year, but we are making strides. We are present right now in 5 countries. We are looking forward to partnering with organizations, institutions, especially universities that we're partnering with right across Africa to have the knowledge base. We'll appreciate people contacting us on, we're very easy to be contactable. We are on the website. We've got a website, www.picta.africa or info@picta.africa. Thank you. Thank you for making time. Everyone who's made time to come and listen to us or participate and join us and support.
Okay, Miss Mini Tagure, sorry, I was, the Mini thing. Any closing remarks from Mini? I think she's muted. Okay, all right. No, that's fine. I think her network is now acting up. It kicked her out. Hugo, I'll just put it over to you before we move to.
No, just thanks everyone for the opportunity. To all of the 3 organizations for putting us together. Always happy to talk about the subject that I'm passionate about, and let's just continue working together. Thanks so much.
Thank you so much for joining us. And I would like to say at Beetroot Africa, we are working very
Okay, I think a network is not stable. Okay, Hugo, it seems like you were cut off. She couldn't hear as she picked up the conversation, and I think your network is a little bit down. So it was sort of rushed.
No, that's perfectly fine, Martha. I just wanted to say thank you to everyone and all the listeners, and I just said let's continue working together and keep growing IP and entrepreneurship across Africa.
Okay. All right. Thank you so much to all the listeners, to all those who asked the questions, and for tuning in to Radio 54 African Panorama. We'll bring in the guests, with a follow-up show. And I believe that Hugo also provide a document that once he speaks to the organization, that will put on Radio 54 African Panorama website, and also try and upload as much as we can and keep sharing this so that it can reach more people. And this is, like I said in the beginning, this is a topic that most people are not really, exposed to. There is not much being shared out there. So you can also follow Hugo on LinkedIn. I think I'm trying to pick his name. The pronunciation keeps. That's Hugo Biermann. GoBiermann. Yes, so that you can follow him on LinkedIn, on his all social media, and the organization is ENS Africa. You can also follow them on social media. Then PICTA as well. They are on Facebook, Pan African ICT Association. Beetroot Minita Gray is also on Facebook and LinkedIn, so you can all follow. I'm also on Facebook and everywhere, so so that you can also get updates, more information on what's happening. We'll also share the links both from YouTube and Facebook. YouTube and Facebook will reshare these links so that we can reach more people, so that you can also get more information regarding this. And next week, Sunday, in celebration of Africa Day, that's 23 May. Okay, Africa Day is 25, but on the 23rd, we're gonna have another show, bringing in another very, very, very big person to talk about all of technology. And the next topic will be Africa Day webinar, technopreneurship. So I'll advise all of you guys to tune in, the impact of 4IR technology on Africa, the future of work and its role in achieving the Africa we want, with Professor Mtunzi Mdwaba. So you all need to tune in and make sure that you are here live with all of us. And thank you so much, Tim. We'll get in touch. And this is the end of our today's session, the end of our broadcast live from Radio 54 African Panorama.
Thank you, Martha. And Dr. Rabu Rifi is going to be online that day, yeah?
Okay.